Thank you very much, viewers. We are continuing with the coverage of Kenya and Africa at a glance. And this is Punchline Africa TV. Today, something very special is happening in Kenya. The Building of Bridges Initiative Challenge, where the Supreme Court is hearing a petition, an appeal, or a submission to the Supreme Court to seek guidance on whether the BBI goes ahead, or the BBI stops, or the BBI collapses. Whichever way the BBI goes, the country Kenya needs a redemption strategy. You can go to any place. You can even ask Angel Gabriel. You can ask Angel Gabriel and ask, what does Kenya need now at the moment, Miriam? There's one thing you will find. My dear sister, you need a redemption strategy. If I'm wrong, take my papers that I studied, take them away from me, and I remain with nothing. I will be happy citizen, die and go before Jesus Christ, and heaven be judged, whether I go to hell or heaven. But Kenya at the moment, Miriam, east or west, needs a redemption strategy. Thanks. It needs a redemption strategy. There is no way, no shortcut. Don't tell me a story. Don't tell me anything more. Listen to President Uhuru Kenyatta. And most of the time when I tell some of my friends, they think I'm stupid. I'm not. I have been there, I've seen. For us in Uganda, if we did not wake up, if we did not wake up, Miriam, from slumber and agreed to do a redemption strategy, Uganda was gone. We agreed to heal the wounds of the South, the Bantu against the Luo against Bantu. We healed that divide. I am one of the few architects of that healing process. So when I'm telling my Kenyan friends, you can insult me, you can twist words on me, I am now not better. I'm sorry. And let me speak. Because some people sit down and talk childish behavior. I'm not a child. We did a redemption strategy in northern Uganda. President Uhuru Muigai Kenyatta is correct. Raila Amolo Odinga is correct. Those looking for elections, a bad election, a badly managed election, a badly prepared election, Miriam, a badly arranged election, a badly sourced election, a badly inequality, where you have inequalities overweighing quality, is a disaster to war. I have made my point very clear, I think, Miriam. We need healing, we need reconciliation. If you go to the Rift Valley today in Eldoret and tell somebody that Ruto will lose an election, in fact, you might not eat food there. Miriam, I'm telling you practically. Yesterday, a friend of mine, he's from Mount Elgon. He told me frankly, they were having a beer with his friends. And they said, whichever way this thing goes, whether Raila, when he mentioned the name of Raila in Eldoret in a restaurant where he was, even his own friends almost poured beer on him. Is that the country that you say is reconciled? The answer is no. The country is not reconciled. The country has not healed. Ruto spews garbage. Another side spews garbage. Stones are being thrown at an Embakasi rally. Madoadoa words are being used at Eldoret rally. The people living in Eldoret area who are not from that Rift Valley are being told, some of them are even getting worried, those who are settled down, about the utterances that are being made. Therefore, for me, the only way that the Supreme Court can revive this country, the only way the Supreme Court can make this country a better place for the whole of Africa is by allowing a special way out for people to reconcile before 8th or before 9th of August. Miriam, other than that, my dear sister, prepare your vote, but you know very well, none of the contestants on the ballot will accept defeat easily. Okay? Back to you, ma'am.
All right, Doc, thank you so much for that. And of course, we're having part of that conversation in lines to the preparation of the elections coming up in August. Before we took that a break going to the Supreme Court, and we are waiting. The Supreme Court judges took a break, and they'll be back again to bring us the latest. So what we know is happening at the Supreme Court today is that it has been asked to determine whether the task force report, the BBI task force report, which culminated in the BBI appeal, is constitutional or not. Both the High Court and Court of Appeal said it was not. Today, however, the Attorney General will be seeking to demonstrate that the two lower courts were wrong. And from the judgments we saw, Doc, from these other two courts, the High Court and the Court of Appeal, was the case was not nullified so much on the content on the BBI, but perhaps the process that culminated to giving us that report. So what are we likely to see today from the Supreme Court?
Yeah. The truth here is this, and I always stick by my truth. What we see today here, Martha Karua is asking for amicus. If you are amicus curiae, or amica, as they are calling it now, but it's called amicus curiae. I have been an amicus curiae in the ICC, International Criminal Court. Several occasions I have, you enter there with an article. There is an article that specifies, I think it is Article 101, that says you are an amicus, a friend of the court. You don't turn somewhere and develop your wings and become a participant of giving views based on one side. And amicus curiae, you remain stable. You remain a man who tells the court, who tells the judges that if you go this side, you will err. If you go that side, you will err. The best thing which you have omitted is A, B, C, D. That's an amicus curiae. The best thing that Ocampo has omitted is he went cut and paste. He did not interview the witnesses. I am now telling you the court, my lordships, the appeal chamber 5. This is me who was doing it. I'm telling you, my lords, that this evidence was not collected from the people who suffered. This evidence was collected from meat and pork joints, where people were eating pigs, where pork and people were eating meat. And my honor, my lordship, I'm telling you that the situation of Kenya was faked by NGOs. You know, and this is how the NGOs did it. I'm telling you, my honor, the government in Kenya is not able, you get my point, is not able to force somebody to give a bank statement or his bank accounts without a court order authorized by a court. And it will take days and days, Miriam, days and days for that government to be able actualize the real order. So the judges look at your analysis, submit it, use it. But as we stand now, the tidings are very clear. So I think let's cross over back to the court, and we see the judges have come back. They are going to decide on whether you are an amicus curiae, you can become the owner or the subject and develop. Oh, if you are, I think what Mr. Stephen should do, should split the screen and leave us on the screen. Some of the words we shall come in. You, the production team, split the screen where we can hear. And if you feel like there's something to come in, we shall come in to say we can stop at any time and come in and say that is where the matter is. So let's hear from the court at the moment. Thank you.
Be appreciated. Since if you look at our written submissions, we are almost dealing with all the issues that are being raised by the appellants. So we'd pray that you give us 5 additional.
Is that she made that application as the Deputy Secretary General of the Third Way Alliance. Therefore, the 1 hour allocated to the Third Way Alliance parties, that is the 7th and the 9th, will be shared with Felista Wakesho. So our time is not 45 minutes, but 1 hour to be shared with the Third Way Alliance because they were pursuing the same issues in the High Court. As regards the participation of the amici curiae who are joined in the High Court, the position of this court is that they remain amici, friends of the court. We will consider their submissions and also whatever submissions were done in the High Court and in the Court of Appeal. We will not allow them time to submit. Those are the further directions of the court. We were told that we need to give this matter all the time, and we agree it is a very important matter. But we have also done research. Supreme Courts all over control their own proceedings and give time allocation. And we have also considered the case that was cited by Senior Counsel Dr. Kaminwa in India, the case, Navande case, which was heard for 69 days. We've also looked at the Supreme Court rulings now of the Supreme Court of India. There is time allocation. That was a long time ago when there was no technology, no written submissions. Now we have written submissions. It's only a matter of highlighting the submissions. So we'll give you the time to do the highlight, and we'll read the record of appeal that is before us and whatever was in the other courts. That said, we will now proceed to hearing by calling the first appellant's case, who has 1 hour, and you can indicate the time that has been donated to you so that it's all put together.
I'm also obliged we seek leave to withdraw since we have no role.
Yes, leave granted. Is that the first appearance case?
My Lady, the Chief Justice and President of the Court, my Lords and my Ladies, good morning. May I begin by thanking you, my Lords and my Ladies, for the opportunity to appear before you and to make these submissions on behalf of the Honorable the Attorney General. And for the record, my name is Kennedy Ogeto, the Solicitor General. And just to confirm, my Lady, my Lords, you have given us an additional 15 minutes. The Speaker of the National Assembly and the Speaker of the Senate had also donated 10 minutes each. So in total, my understanding is that we have 35 minutes in addition to the 45 minutes that we had originally been allocated.
That is correct.
Many thanks. This appeal raises a number of important legal and constitutional matters, but in our view, my Lady and my Lords, these issues principally revolve around two main questions. The first question is, what is the import of our written constitution? And the second question, how much and to what extent can we imply meaning into constitutional provisions that are, in our humble view, otherwise conclusive and unequivocal? Our appeal does not just seek the answers to these questions, it also seeks, with equal anxiety, the justification for the answers, whatever those answers may be. Our singular desire in this appeal is that the lingering legal and constitutional questions in this appeal be determined and settled by the highest court in our land, not just for today, but also, and perhaps more importantly, for posterity. Through our oral and written submissions, we contend that the learned judges of the Court of Appeal answered important questions the wrong way, and that they had the wrong, often ambiguous, and in some cases contradictory justifications. The first matter I will highlight concerns the applicability of the basic structure doctrine in Kenya. We submit, my ladies and my lords, that the learned judges erred in holding that this doctrine applies in Kenya. At the outset, we have no doubt that our constitution has a basic structure. No one can deny that all constitutions have some basic structure. We submit that in our case, that basic structure is outlined in Article 255(1) of our Constitution. Our Constitution tells us that it is amendable. It also tells us how it should be amended. It does not impose any limit to its amendability. And yet the learned judges of the Court of Appeal are in agreement, erroneously we submit, with the High Court that the basic structure of the Constitution is amendable only through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation, constituent assembly debate, and ultimately a referendum. With tremendous respect, we disagree with this position. Neither our Constitution nor its history contemplate the doctrine. We agree with the learned judges of the High Court and the Court of Appeal that Kenya has had a history of indiscriminate constitutional amendments. We, however, note that the people were fully conscious of this while making the new constitution. Page 73 of the final report of the Constitution of Kenya Review Commission, CKRC, captures this concern, and I quote, "Considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new Constitution from a similar fate?" End of quote. And I underline the words quickly and fundamentally. And this report is available in volume 13 of the Bundle of Authorities at page 1753. I have to emphasize, my lords and my ladies, that a plain reading of this report clearly indicates that the problem that was identified during our 2010 constitution making process had 2 components to it: quick amendments and fundamental amendments. Page 75 of the final CKRC report identified the people's solution to this problem, and I quote, "A distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions." End of quote. This solution is given effect in Chapter 16 of the 2010 Constitution. The procedure for amending the entrenched provisions, which is the basic structure, is elaborate and onerous. Our humble view is that judicial intervention ought to be limited to confirming that this consciously elaborate and onerous constitutional procedure is strictly observed and followed in amending the Constitution. The learned judges of the Court of Appeal erroneously elevated the basic structure doctrine to a universal template for certain constitutional amendments or change. This fails, my lords and ladies, to recognize that constitutions are not identical. In our humble submission, where a constitution creates an amendment power that is similar to the exercise of the primary constituent power by being inclusive, deliberative, and democratic, such as is the case in our Constitution, the basic structure doctrine has no place. Problematically, my lords and my ladies, the learned judges do not agree on what the basic structure is. In paragraph 474G of its judgment of 13th of May 2021, the High Court had told us that what constitutes the basic structure will be determined on a case-by-case basis. In the Court of Appeal, Lady Justice Nambuye, for instance, states in paragraph 62 of our judgment that the basic structure of the Constitution is, quote, "the Constitution itself and what it contains," end of quote. Lady Justice Okwengu, on the other hand, at paragraph 82 of our judgment, expresses the position that, quote, "the framers of the Constitution either consciously or unwittingly identified the basic structure of our Constitution through Article 255," end of quote. According to Justice Kiage, at page 85 of his judgment, Article 255 of the Constitution, quote, "either coincides or nearly coincides with what may be considered to be the basic structure of our Constitution," end of quote. Finally, Justice Kairu and Justice Tuyot are certain in their respective judgments that Article 255 of the Constitution outlines Commission on Constitutional Commissions and Amendments to the Constitution, which recorded as follows, and I quote, "The committee introduced a novel idea called popular initiative. The committee explained that their intention was a starting point towards curbing dictatorship by parliament," end of quote. And that report is available in volume 18 of our bundle of authorities, page 26-22, and the quotation will be at page 4 of the report. Again, my lords, my ladies, the learned judges do not agree on the implications of their finding that the president cannot use the popular initiative route to amend the constitution, or the options available to a president who may wish to spearhead constitutional changes. In paragraph 490 of its judgment, the High Court told us that the president can use the parliamentary initiative route through the Attorney General. Justice Musinga agrees with this position in paragraph 347 of his judgment. Lady Justice Nambuya in paragraph 99 of our judgment, and Justice Cairo in paragraph 81 of his judgment agree as much. On his part, Justice Kiage holds in paragraph 109 of his judgment that the president is under duty to obey but not change the constitution. So according to Justice Kiage, changing the constitution is tantamount to disobeying the constitution. Lady Justice Okwengu, Lady Justice Sichale, and Justice Tuyot do not express themselves on these matters. This absence of clarity, my lords and my ladies, is clearly problematic. In addition to the foregoing, the learned judges do not consider the consequence of their finding to a president who, having been elected on the platform of arguably necessary constitutional reforms, finds himself facing a partisan and hostile parliament, perhaps because he has a minority in that parliament, or because he was elected as an independent candidate. Justice Kiage, the only one who expresses his view on this point at page 109 of his judgment, terms this situation as hypothetical. We humbly submit, however, that such situations are a real possibility under our constitutional architecture and therefore require contemplation and an answer which we call upon you, my lords and my ladies, to provide. The third and last question, which I wish to briefly highlight, relates to the question of presidential immunity from civil court proceedings. And here the majority in the Court of Appeal held that civil proceedings can be instituted against the president during his tenure of office in respect of anything done or not done contrary to the Constitution. I wish to highlight two obvious problems with this. First, in order to determine whether the president has done or not done anything contrary to the Constitution, there has to be a judicial process. And this defeats the whole essence of immunity as the president would have to participate in the process to prove his innocence. Second, immunity from legal process recognizes, as a matter of common sense, that the holder of immunity, in performing his functions, engages in conduct that may expose him or her to legal process. If therefore there was the expectation that the office holder's official conduct must always be perceived as lawful, then the whole question of immunity would be redundant. My lords, my ladies, my other colleagues acting for the Honorable the Attorney General shall endeavor to demonstrate to my lords and my ladies additional problems with the findings of the learned judges of the High Court and the Court of Appeal. At this juncture, may I, with your permission, lords, my ladies, invite Senior Counsel George Oraro, followed by Mr. Kamau Karori to present the arguments, and Mr. Nyamodi will deliver our rejoinder at the end of the proceedings. Many thanks and most obliged.
Thank you, Chief Justice, members of the court. The Constitution of Kenya commences with very powerful words, and that is, we the people of Kenya, acknowledging the supremacy of the Almighty God of all creations, and exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution, adopt, enact, and give this Constitution to ourselves and, more importantly, to the future generation. Article 1 of the Constitution thereafter contextualizes the sovereignty of the people and further asserts that this sovereignty can be exercised either directly or indirectly at Article 1(2). The people of Kenya have further delegated their power to state organs, including the judiciary, as specified in Article 1(3). But the exercise of such delegated power must be strictly in accordance with the Constitution. In the result, the people of Kenya, by their constitutional text, reserved the sovereign power to be exercised directly where it has not been delegated or it is not being exercised through democratically elected representative. And it is in this context that in the CKRC report at paragraph 744, and that is found in volume 13 at page 1851 of our list of authorities, at paragraph 7 they state as follows: all power and authority should derive from the people of Kenya, and the people should be governed through their will and consent. The people reserve to themselves all the power and authority that they do not expressly delegate to the state and its organs. So ours is a participative constitution in which the people are fully involved. It was on that account that in formulating the provisions for amendment of the Constitution, it was recommended at paragraph 746 of the CKRC report, and you find this in page 851, volume 13 of our list of authority. They stated that a number of key constitutional issues should be enshrined in the Constitution, that they should be amended only by a referendum, so that a referendum in accordance with the Kenyan Constitution as mandated by the people was an exercise of sovereign power and not a delegated power. It is not strange that has been incorporated into our Constitution. And indeed, in the famous case which has been relied on to justify the basic structure doctrine, the case of Njoya, it is always stated that at that stage the basic structure doctrine was recognized, but Njoya also recognized the textualization of the sovereign power. And you'll find that in our list of authority at page 24, where in Njoya, this is what Justice Ringara found. The second stop is recognition that sovereignty of the people necessarily tokens that they have a constituent power, the power to constitute and or reconstitute, as the case may be, their framework of government. That power is primordial one. It is the basis of the creation of the Constitution, and it cannot therefore be conferred or granted by the Constitution. Indeed, it is not expressly textualized by the Constitution, and of course it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they would do so only ex ante cautela. And that is what they did in our Constitution. This case was in the repealed Constitution, and in the new Constitution, they now ensured that they textualize the sovereign power of the people. The Constitution of Kenya thus places the people and the exercise of their sovereign power at the core of constitutional operation and enforcement. And for that purpose, it incorporates a very a permissive amendment provision under Article 250, granting the courts the power to advance the contemporary aspirations of the people with this court as the final arbiter. And that is where we are. The direct democracy, which is referred to at Article 1(2), is exercised through the national values and principle of governance pursuant to Article 10, public participation in legislation for Parliament, Article 118, and for county assemblies, Article 196, and finally, in constitutional making through popular initiative, that is Article 257, and of course, public discussion in amendment by Parliament at Article 256(2), and finally, that sovereignty is exercised through a referendum to amend those matters which have been specified at Article 155(1) by the provision of Article 255(1) by the provision at Article 255(2). It is because of this peculiar character of our Constitution that this court, in dealing with the amendment power under Article 259, had the following to state in its decision in petition number 13A of 2014, Judges, Magistrates Vetting Board and 2 others versus Center for Human Rights and Democracy and 11 others. This is what this court had to state. It stated that although certain jurisdictions such as India and Germany have perceived judicial review as an immutable structure of their constitution, and hence the basic structure doctrine, these jurisdictions do not have constitutions that are as unique as Kenyans. We must ask whether these foreign jurisdictions we seek reliance upon have constitutions, and if they do, whether these constitutions have provisions akin to Articles 1, 23, 159 and 259, and I would add to that 257 and 255, which emphasize the sovereignty of the people, or whether they have principles and values like the ones found at Article 10, which apply to the interpretation and application of the Constitution, or whether they have legislation similar to our Supreme Court Act, which introduces Kenya's historical context into the interpretation of the Constitution. If the answers to those questions are in the negative, and indeed they are, then the common law doctrines found in other jurisdictions, foreign cases, and foreign constitutions must be interpreted in such manner as to reflect our modern constitution and our unique conditions and needs. And that's what I'm requesting this court to do. Look at this purported introduction of limitation to the constitution by a foreign doctrine and find out whether in the context of Kenya today, this doctrine can apply to what the people had determined to be applicable to them. That notwithstanding, both the High Court and the Court of Appeal found that there is a limitation to the constitutional amendment powers under Chapter 16, Articles 155, 156, and 157, read together with Article 1 and with very permissive provisions under Article 259. The said finding was based on the following grounds. First and foremost, the court found that the basic structure doctrine is accepted in Kenya following the decisions in the case of Njoya and Attorney General, the case of Onyango and 12 others versus Attorney General, and you will find that at page 28 to 121 with the relevant portions of the judgment at pages 67 of volume 1 of the Attorney General's authorities. These were all cases decided under the repealed constitution, and I will go to that in detail, but I would start by commenting that under the repealed constitution there was a single tract amendment provision which placed all the power on the parliament to affect amendments. Under that constitution, parliament was purporting from time to time to overturn the basic structure without reference to people, and therefore, in that context, the basic structure doctrine applied. But does it apply in our current context, which has a multi-tract amendment provision, as we will show you? The other decision they relied on was decision in Commission of Implementation of the Constitution versus National Assembly of Kenya and two others. It was a decision by my learned judge when he was in the High Court, and it was based on an attempt by Parliament to alter a provision which was entrenched under Section 151, and the issue there was limited to the power of Parliament to amend. Now, contrary to those decisions, the courts subsequent to the amendment of the Constitution and before the decision in this case, in the case of Priscilla Ndululu Kivuitu and another suing as personal representative of Samuel Mutua Kivuitu and Kiara Mutu, my ladies, you find that at page 142 to 182 and at page 177, found that the basic structure doctrine is not applicable to Kenya in view of the amendment provisions under the new constitution. Though this finding was obiter, but that was the finding of the court, 3 judges. You find that at page 142 to 182, and the relevant finding is at page 177, volume 2 of our authorities. The Court of Appeal has been more succinct, and in the case of Senate and 48 others versus Council of Governors and 54 others, 2019, you find that at page 183 to 202, at page 154 of volume 2 of our list of authority, they expressly found that Kasavananda no longer applies to Kenya in view of the new constitution, a bench of 5. Again, in the case of Attorney General and another versus Randunzai, Rua, and five others. They came very succinctly and expressly, and now clearly stated that all the provisions of the Constitution were amendable so long as Article 255, 256, and 257 are followed. And you will find this case in our supplementary bundle. The relevant finding is at page 19. Due to time, I will not read it, but if I get a little time, I'll go through it. Now, following that, there was clearly a contradiction between the position now held by the court in this case and the earlier decisions made by the Court of Appeal, which were never distinguished in their decision. It now falls upon you as the final court, and the court granted this power to reconcile these contradictions and come up with a very clear position whether there is any limitation to amendment power as granted under the Constitution. My humble submission is that there is not, because as the SG had stated, the provision of amendment under the Constitution are very clear. The other ground which they relied upon was that an amendment provision in a Constitution are secondary powers granted by the exercise of primary constituent power and cannot therefore alter or amend what has been created by people exercising their primary constituent power. This is based on a constitutional doctrine which was later advanced to the doctrine of basic structure as articulated in the case of Kesavananda in India. However, the Kenyan Constitution has distinguished between the matters which can only
Good morning, viewers, again. Oh, good. As I predicted, I was right, Miriam, that amicus curiae cannot become a respondent. So, you know, with this BBI, you can't laugh and celebrate before it is over. The other time we had made several points, predictions, but my prediction on the question of amicus, which they are calling amic, but it is amicus curiae, as you call it, depending on which part of the world you come from. It is, therefore, it was decided Martha Karua has nothing to do. She wanted to turn herself into a respondent as if she had applied as a respondent. And therefore, Miriam, it was not accepted. She finally bore out. She's no longer interested. It means she's now very upset. You know that very well. She had come in to stop the entire PBI. So are these good signs?
Well, I think, Doc, at this point, it's very hard to tell. So perhaps we'll continue following, and maybe tomorrow we can have, a proper conversation around it, because the submissions are just ongoing. Of course, as you mentioned, there, Martha.
No, the first submission so far It's a good sign for the appearance, for the people who made an application to go to the Supreme Court, because they have struck off the contentious lady. Actually, her points were so contentious that if she did not mix it up with being an amicus curiae and a respondent, my God, the floor would have had water and fire. London is burning. London is burning. London is burning. Set the engines, then the fire. I used to sing that in primary, secondary school. I don't know whether Miriam, you came also across that.
Yeah. In primary school. Yeah. So anyway,
thank you very much. Yes. Yeah, go ahead.
Okay. As the Chief Justice, Martha Koome, there said that, of course, the amicus curiae will not be given an opportunity to present, but perhaps they will only highlight the written submission by the friends of the court, and Oraro is giving his case there. So I think I'll be in a much better position to speak on it, perhaps tomorrow after listening in through, what is going on right now at the Supreme Court.
No, the Chief Justice did not. She said their submission will be looked at, but they don't need to give any oral submission.
That's what I said. That's what I said. Yes.
So they lost. No, let's be candid. You are giving them credit. They lost on that because she lost on her own technicality. She turned herself into a respondent. If you are amicus curiae, I was telling you in ICC, when you apply as amicus curiae under rule number 103, Article 103 of the International Criminal Court, you turn into a respondent. You tell the court what is wrong with that, this, that, by the law. So thank you very much, Miriam. Any points from Daniel Wesong? I can see him online.
Thank you so much, Dr. Matsanga, David. And of course, I believe Martha Karua being struck out is a premonition of whatever we anticipate from the Supreme Court. And of course, our expectations have always been that being the highest court in the land, it will actually be able to overturn the ruling by the appellate court, where some judges who are sitting there, and the High Court, where some judges who are sitting there had personal acrimony, perhaps with the promoters of the BBI. So to me, I believe that is the optimism that I have within me. As the submissions continue to go, I expect that at the end of the day, the BBI will have a victory over those people who are the opponents who are trying to pull it down. Because I believe this country needs BBI, and especially as we head to the August polls, and even after the August polls, we cannot say that BBI is maybe a document who has been overtaken by events or time, because at the end of the day, Kenya needs the healing and the redemption strategy, because without that, we shall be walking into the future without knowing maybe specifically how to treat this perennial disease that has been ailing the country, the disease of violence, the disease of divisiveness, and the disease of corruption and stagnation. I submit, Dr. Matsanga.
As that submission continues, I apologize for that, at the Supreme Court. And as I mentioned there, lawyer George Oraro has taken the floor. I did that a couple of minutes ago. So I think we'll be in a much better position to talk about this once today's submissions have been given. Doc, do we move now to our next show, to our topic?
It is sad. I don't know whether we are finished.
Yeah, we are done with that. So I was wondering, should we move to the network topic?
Yes. Now,
Okay.
let's cross over to, I think we bring a new stream, diaspora dispatches. You have some notes as we wait for the court.
Do we
We cut this, we shall switch off and on.